The Assembly Committee on Government Affairs will come to order. Madam Secretary, please call roll.
Assemblywoman Anderson,
Present.
Assemblywoman Black,
Here.
Assemblywoman Brown May,
Here.
Assemblywoman Considine, Assemblywoman Dickman,
Here.
Assemblywoman Duran,
Here.
Assemblyman Ellison,
Present.
Assemblywoman Martinez,
Present.
Assemblyman Matthews,
Here.
Assemblyman MacArthur,
Here.
Assemblywoman Thomas,
Here.
Assemblywoman Torres,
Here.
Chair Flores.
Present. Thank you, Madam Secretary. And while I know Assemblywoman Considine was unable to announce herself, please let the record reflect that she in fact is present in the committee. I can see her. Thank you, members. And we do have a quorum. All members are present. Good morning, members. Thank you for all being here and ready for another great day of government affairs. I know you're all as excited as we are. We have two great folk who are very familiar with our committee coming in today. We're going to take the agenda in the order it appears. I want to remind those of you who are following the meeting virtually, and especially those of you who are logging in for the first time, that every member has the unique setup. And at times you'll see us looking in various different directions. That's just the type of setup. It doesn't mean that we're not paying attention during the presentation. I want to remind members, please maintain your microphones muted unless you are speaking. Please keep your cameras on at all times. If you would like to ask a question, I know some are more comfortable with simply sending me a message, that works. And if you're comfortable with using the chat, that works as well. Just whatever is easiest for you, I can work with you on that. Beyond that, I want to remind folk that we do have two bills again scheduled for Friday. I want to give you an opportunity to review those and that you give yourself an opportunity to go through the agenda so that you're ready for that Friday presentation. With that, I'd like to open up the presentation from our very own Attorney General Ford. Attorney General, whenever you're ready. Good morning and welcome.
Good morning. I'm trying to find myself on the screen here. Anyway, good morning, everybody. I am Aaron Ford. I'm your Attorney General. It's so great to see all of you. Many of you I know because I served with. Many of you I don't know, but I've seen you around. And so congratulations to all of the new Assembly persons on your wins and looking forward to working with you. As I've indicated, I'm Aaron Ford. I'm wearing my mask. I have my second assistant, Christine Jones-Brady, in the room with me. We are 6 feet apart. I'm going to take my mask off as I give the presentation, however, but I just wanted to acknowledge the appropriateness of what we're doing here. I also want to acknowledge those who are on the screen with me, and I'm going to ask them to not unmute, but to show their videos. I have with me, as I've indicated up here in Carson City, my second assistant, Christine Jones-Brady. I have in the South, in the Attorney General's office there, my first assistant, Kyle George, if you wouldn't mind waving real quickly, Kyle. And I have my chief of staff, Jessica Adair, if you wouldn't mind waving there. And on her own screen, I have my Solicitor General, Heidi Perry Stern. So that is my executive team. We have one vacancy in my executive team in our general counsel position because we were fortunate to have a fantastic 2-year tenure with Rachel Anderson, who is a full professor at UNLV's Boyd School of Law. She offered to give me 2 years. I took it, and she has now returned. So we are now hiring in that particular position. I wanted to introduce them to you because they don't know this except for Christine Jones-Brady. I'm going to have them read their portion to you because they are responsible for so many aspects of this office. And I think it's important that you get to know everybody on my team that helps to make certain that we have an Attorney General's office who uses the hashtag "Our Job is Justice" as what it is that we do. So I will begin my presentation as follows. Again, I'm Aaron Ford, happy to serve as your Attorney General. Thank you again for the opportunity to provide an overview of the Office of Attorney General. My office consists of nearly 400 dedicated and hardworking individuals committed to enforcing Nevada law and upholding justice for the protection and benefit of all of our residents. As the state's chief law enforcement officer, the Attorney General's office represents the people of Nevada before state and federal trial and appellate courts in criminal and civil matters. We serve as legal counsel to state officers, legal counsel to state departments, most state boards and commissions, and we work with our local, state, and federal law enforcement partners to protect the public. In addition to my written testimony, I provided the committee staff with an agency organizational chart and a copy of the agency's biennial report, which I've also submitted to the governor's office and released publicly on September the 1st of 2020. While that report goes into significantly greater detail, I'd like to highlight a few key accomplishments of the Office of Attorney General over the last 2 years of my administration. First, we responded to a global pandemic to minimize the loss of life in Nevada, assisting state agencies and thousands of Nevadans who called our office for help. We saved over 1.2 billion with a B taxpayer dollars by vigorously defending the state and providing quality client advice. We also secured tens of millions of dollars in settlement funding and federal grants. We've investigated and prosecuted and defended appeals against those who seek to harm Nevadans, including murderers, abusers, and scammers. We provided robust constituent services to Nevadans seeking assistance, receiving 50,585 written inquiries. We sponsored laws to protect Nevadans. During the last legislative session, some of you may recall, 14 bills sponsored by my office were signed into law. All 14 bills received strong bipartisan support. And I look forward to working with you all again this year to pass laws to improve the lives of Nevada families. Every Attorney General brings his or her own perspective as to how to protect and improve the lives of Nevada. The overarching theme that I have brought to this office and that I've used to set our office's intention is, as I've said, our job is justice. That's justice for all. This guides my decision making, and I've also framed our administration through a set of policy priorities. These priorities do not override our statutory obligations, but rather they serve as a lens through which we view our work. I refer to these priorities as the 5 C's. And if you were to ask, I venture to bet, virtually anyone in any of our offices around the state what my 5 C's are, they could articulate them because they absolutely help to define what it is that we do here. Those 5 C's are constitutional rights and the protections thereof, criminal justice and reform, consumer protection, client service, and community engagement. Each of these C's serves as a moral compass to guide the ways our office can serve Nevada. And our office is composed of several divisions with specific assignments related to the Attorney General's statutory responsibilities in the administration of this office. And with that, I'd like to turn to some of those divisions in more detail. To explain the component of seeking justice for Nevadans through her lens, I'd like to offer my second assistant, Christine Jones-Brady, the microphone so that she can explain to you the divisions over which she operates and manages. Go ahead.
Thank you. Thank you, Chair. Several divisions are dedicated to one of the most sacred responsibilities of the office, seeking justice for victims of crime and protecting vulnerable Nevadans. Our Criminal Prosecution Division is headed up by Chief Michael Kovac. The Criminal Prosecution Division prosecutes financial fraud, including scams, insurance fraud, workers' compensation fraud, securities fraud, mortgage fraud, sex trafficking, cyber crimes, public integrity cases, and crimes that occur in the Department of Corrections facilities. In the past 2 years, this division has charged several murders, including the 1979 murder of a Reno woman in a case thought to have gone cold. elder abuse murders, and killings in Nevada's prisons. We have prosecuted hundreds of cases from child sex trafficking to scams and fraud to animal abuse. The state fiscal years 2019 and 2020, the workers' compensation and insurance fraud units filed 389 prosecutions and had nearly 1.5 million in restitution and costs awarded to the state. As a prosecuting agency, it is particularly important to me that and to the office and to Attorney General Ford that when it comes to criminal justice reform, we do not just talk the talk, but we walk the walk. Our office has adopted new internal policies to ensure that our charging decisions and bail requests are appropriate and ethical. We incorporate the victim's wishes whenever practical, and we seek justice, not vengeance. The post-conviction unit is headed up by Chief Heather Proctor. The post-conviction division handles petitions for habeas corpus in state and federal courts. The division is also responsible for representing the state in death penalty appeals. In the past biennium, the division handled 11,666 federal habeas cases and 5,797 state habeas cases. The division is also responsible for implementing the law passed by this body last legislative session to compensate those Nevadans wrongfully convicted of crimes they did not commit. The Medicaid Fraud Control Division is headed up by Chief Andrew Schulte. The Medicaid Fraud Unit investigates and prosecutes fraud by healthcare providers in the Nevada Medicaid Fraud Program. For the past biennium, the Attorney General's Medicaid Fraud Control Unit opened 80 investigations, closed 67 investigations, and has successfully prosecuted 34 criminal cases involving fraudulent activities by companies scamming the Medicaid system. In the process, the division recovered $13,510,403 for state fiscal years 2019 and 2020. The MFCU, the acronym for it, also reviews reports of abuse or criminal neglect of patients in facilities that use medicine. This unit focuses on community engagement, partnering with medical schools to train students on how to identify signs of elder abuse and neglect. The Consumer Protection Division is headed by the consumer advocate, Ernest Figueroa. The Consumer Protection Division diligently works to protect Nevada consumers from economic harm. The division has 4 primary areas of focus. 1, advocacy for ratepayers before the Public Utilities Commission and Federal Energy Regulatory Commission to ensure ratepayers receive reliable utility service at a reasonable cost. 2, protecting consumers through enforcement of Nevada Deceptive Trade Practices Act. 3, prevention of unfair markets through enforcement of the Unfair Trade Practices Act and federal antitrust law. And finally, 4, administration of the Home Again Nevada Homeowner Relief Program. In the past 2 years, this division has been responsible for bringing tens of millions of dollars to the state as a result of settlements with companies who violated Nevada's consumer rights, such as consumer data breaches. Of note, we negotiated a settlement in the T-Mobile merger to guarantee that every T-Mobile job in Nevada will stay in Nevada and employee bargaining rights will be protected. Additionally, T-Mobile will offer low-cost plans for Nevadan consumers and build out coverage for rural internet services. This team is also responsible for responding to thousands of COVID-19 related complaints, such as price gouging, failure to issue refunds, illegal evictions, and scams. The BCP, as we call them, Bureau of Consumer Protection, also represents ratepayers before the Public Utilities Commission, saving them from increased utility costs, especially due to the fiscal impact of the pandemic. This includes litigating a general rate case before the Public Utilities Commission, resulting in a $120 million credit to ratepayers in Southern Nevada. Consumer protection staff also help Nevadans protect themselves from scams through community outreach and education programs. Finally, the Investigations Division is headed by Chief William Scott Jr. The Attorney General investigators work diligently with our prosecutors and local federal law enforcement partners to investigate a wide array of criminal activity. Since January 2019, the Investigations Division has received over 8,000 complaints, completed over 1,000 investigations, and referred over 530 cases for prosecution, arrested 246 subjects, and recovered 81 missing children. Additionally, the AG's office provides vital support to Nevada through multi-jurisdictional task forces such as the IRS Financial Fraud Task Force, the Child Exploitation Task Force, the Healthcare Fraud Task Force relative to opioid-related matters, the Southern Nevada Human Trafficking Task Force, the Elder and Vulnerable Persons Investigation Task Force, and the FBI's Joint Terrorism Task Force. The Investigations Division has also focused on engaging with the local community to better foster relationships and trust with the people who serve.
Thank you, CJ. CJ joined us soon after I was elected. She was a former public defender and has been an integral asset to all that we do over the divisions in which she oversees. And so thank you again. I want to introduce her to you. I'm going to read these next couple of provisions, but I want next up is going to be Kyle George, who is my first assistant. But let me first speak quickly to the domestic violence ombudsman role that we have here in our office. Nicole Riley. Nevada holds the unacceptable distinction of being one of the worst states for domestic violence. Probably all knew that. The domestic violence ombudsman serves as a liaison with all state and local partners on issues related to domestic violence, sexual assault, and human trafficking. The ombudsman serves as a state-level coordinator with oversight of many programs and initiatives, including the statewide Committee on Domestic Violence and Nevada Vine. And Nevada Vine is a statewide automated system that allows victims to receive timely, accurate information on the custody status of offenders. Jessica Adair, my chief of staff, may want to offer more insight on that. She is also very instrumental in all that we do in this arena, especially when it comes to our legislative priorities on that. The next division I want to speak to is a division that was begun by my predecessor, Adam Laxalt. To his credit, it was a fantastic initiative, and I have, in my administration, continued it. It is the Office of Military Legal Assistance, run by Special Assistant Attorney General Nick Dana. The Office of Military Legal Assistance, OMLA for short, provides pro bono legal advice for veterans and military families in civil matters, and is the first of its kind in AG offices across the nation. In fact, it's become a blueprint that many have copied over the course of the last few years to implement their own program. Since the program's launch in November 2015, and with the assistance of our pro bono legal aid partners, the OMLA has helped over 3,650 service members and veterans. Even during the pandemic, the OMLA continued operating virtually, particularly assisting military families facing evictions. With that, I'd like to introduce you to my first assistant. And CJ's my second assistant, Kyle's my first assistant, but that's only because I had to use numbers. They are equal and on par, and they have very important roles within our office. And with that, I'd like to offer Kyle the microphone to talk about representing our state. Go ahead, Kyle.
Thank you, General Ford. Good morning, committee, Mr. Chairman. For the record, my name is Kyle George. I'm the First Assistant Attorney General. As General Ford indicated, I did not have a heads up. I will be reading this, so bear with me. The Office of Attorney General represents all constitutional offices and state executive branch agencies, as well as many statutory boards and commissions. The attorneys within these divisions have a broad range of expertise, including the fields of state and local taxation, business law, regulatory law, election law, employment law, constitutional law, and civil litigation. It is in these divisions that that Attorney General's forward priority of client services is paramount, although staff often find ways to incorporate other priorities as well, including the protection of constitutional rights. Our gaming division is led by Chief Darlene Caruso, and the staff of the gaming division advise the Nevada Gaming Commission, the State Gaming Control Board, the Nevada State Athletic Commission, and the Nevada Gaming Policy Committee. In addition to daily legal advice, staff also represent the board and commission at monthly public meetings. Litigation in this division includes disciplinary actions brought against gaming licensees, disputes regarding taxes and fees, hearings on the surrender of gaming licenses, and actions to add to the list of excluded persons. Our Boards and Open Government Division is led by Chief Rosalie Bordelove, and the Boards and Open Government Division provides counsel to all NRS Title 54 occupational licensing boards on administrative law and procedure, administrative rulemaking, the law of licensure, and open meeting law. Deputies in the division attend meetings of the boards and commissions, as well as serve as prosecutor and board counsel in disciplinary proceedings against licensees. Staff are also responsible for enforcing the open meeting law for all public bodies. The Government and Natural Resources Division is led by Chief Greg Scott, and this division serves client agencies and officials responsible for providing core government infrastructure, such as the Controller, the Department of Administration, the Nevada Indian Commission, and PERS. The division also serves agencies responsible for managing and protecting the state's natural resources and environment, such as the Department of Conservation and Natural Resources, the Division of Environmental Protection, the Department of Water Resources, the Department of Nuclear Projects, and others. Attorneys in this division helped come to settlement agreements with the U.S. Department of Energy to remove plutonium shipped to our state without our consent. The Health and Human Services Division is led by Chief Julie Slaybaugh. Staff in the Health and Human Services Division serve as counsel to the Department of Health and Human Services and many of its subdivisions. The OAG advises DHHS on some of the most critical matters to Nevadans, which includes services at its divisions of healthcare finance and policy, Medicaid, welfare and sports services, health, mental health and developmental services, aging services, and the Division of Child and Family Services. As you can well imagine, this team has been absolutely critical to the state's COVID-19 response over the past year. The Attorney General's Office Personnel Division is led by Chief Cameron Vandenberg, and this division advises executive branch departments, divisions, and agencies on employment law, including administrative hearings regarding discipline of state employees, judicial review of administrative proceedings, resolution of grievances before the Employee Management Committee, and litigation in state and federal court regarding employment relationships. Our Public Safety Division is led by Chief Randy Gilmer. The Public Safety Division advises the Department of Corrections and provides representation in all inmate-related litigation, including property and constitutional claims. Staff in this division also participate in the Inmates Mediation Program, a unique program of alternative dispute resolution for inmates. Almost done. The Transportation Division is led by Chief Dennis Gallagher, and this division advises the Transportation Board of Directors and many divisions of the Department of Transportation. Staff in this division provide counsel on many complex transportation matters. Attorneys in this division also represent the Department of Public Safety and its many divisions, including parole and probation, as well as the Department of Motor Vehicles. And lastly, the Business and Taxation Division is led by Chief David Pope, and this division provides daily legal advice to the Department of Taxation and the Department of Business and Industry and its 11 divisions, including the Division of Real Estate, Mortgage Lending, Insurance, Financial Institutions, the Taxi Cab Authority, Transportation Services Authority, the Labor Commission, Consumer Affairs, Housing, Industrial Relations, and OSHA. Attorneys in this division also enforce the Tobacco Master Settlement Agreement and its compliance program to prevent underage smoking. Staff from this division also represents the newly created Cannabis Compliance Board and prosecute violations of cannabis licenses.
Thank you so much, Kyle. Kyle joined this office soon after I got here as well, with a varied experience, including as a prosecutor in Mineral County, a congressional staffer, a doctoral student in chemistry, and has a great background and offers a lot to the officer. So thank you so much, Kyle. I wanted you all to meet him as well. I'd like to introduce you to Heidi Perry Stern. I have known her longer than anybody in this office. 20 years she and I go back as co-clerks for the Ninth Circuit Court of Appeals here. And she is my Solicitor General, a very small paragraph, but a very big part of this office. And Heidi, if you wouldn't mind.
Thank you so much and good morning. Solicitor General Heidi Stern. The Office of the Solicitor General oversees all appeals before the Nevada Court of Appeals, the Nevada Supreme Court, and the Ninth Circuit Court of Appeals. It also houses the Complex Litigation Division, which is a team of highly specialized and experienced attorneys who work with staff in all divisions on complex matters or cases that expose the state to great financial.
I've indicated a small paragraph, but believe me, she's been one of the busiest in our office, especially during COVID. I talked about having 5 C's. That 6th C that I didn't introduce that was thrust upon us was COVID. And Heidi Perry Stern's group, especially the complex litigation and the appellate group, has been very busy over there. So thank you so much, Heidi. I'd like to introduce you now to my Chief of Staff, Jessica Adair. I have a lot of bosses here in this office, 400 to be exact, but she's probably the bossiest. But that's because she has a lot to do here. So Jessica, if you wouldn't mind introducing yourself and telling us what you do at the office.
Thank you, Attorney General Ford. Jessica Adair, Chief of Staff for the record. I'm proud to oversee our administration division. The Office of the Attorney General is more than one of the largest law firms in the state. It also represents a constitutional office elected by the people of Nevada to serve our state. The Office of Attorney General has a lean yet efficient staff who support the daily functioning of a large agency. The administration division includes IT personnel, human resources staff, office managers, and legal secretaries dedicated to each legal division. The communications team manages a robust public outreach program to help Nevadans protect themselves from crime and respond to media inquiries. The Constituent Services Unit is responsible for attending to all complaints, concerns, and questions sent to the Office of the Attorney General. CSU staff processed over 18,000 emails and complaints in 2019 and over 32,000 emails and complaints in 2020. This does not include the thousands of phone calls and walk-ins to the office. The administration division also houses the chief financial officer, who oversees fiscal analysts, tort claims administration, and the grants unit. The grants unit is currently administering 17 grants for a total of nearly $16 million. The grants unit manages several federal programs focusing on supporting victims of domestic violence and sexual assaults, elder exploitation, and youth gang suppression. The grants unit has developed close relationships with local, state, and federal agencies, victim services providers, and others to administer grants across our state. Thank you.
Thank you so much, Jessica. And again, she's very important to the office. She essentially oversees every operational component that you could imagine. And so thank you so much for your work on that. So listen, committee, looking forward, it's clear that we have, as elected officials, a lot of work to do in order to build some trust in the community. Our nation and our state are divided, and trust in our government is broken. Many of our neighbors trust what they read on the internet more than the people that live with them in their communities and the people who are elected to represent them. As I've often said, as representatives of the government, there are 3 types of communities in which we must seek to build trust. We must augment trust in communities who have always believed in the government. We must restore trust in communities who historically trusted the government, but that trust has been broken. We must create trust in communities that have never trusted the government in the first place. In the next 2 years of my term as Attorney General, my special focus is to restore, augment, and create trust in this agency and the state. We will do so by doing our job to the best of our ability every day, providing the best client service, being transparent about our agency, following through on our commitments, always making decisions based on what is in the best interest of Nevada. And when Nevadans are in need, we will continue to answer their call. So thank you so much for having me. I look forward to working with each of you. Mr. Chair, I turn the mic back to you, and I'm happy to entertain any questions.
Thank you again, Attorney General Ford. It's always a pleasure to have you here. And I wanted to personally thank you and namely all the folk around you, as you understand how important they are for all the work they've done during this pandemic. There is no question that you all have been stepping up and doing great work in the community. And I just wanted to applaud you and thank you for that. I know we still got a lot of work to do, but you're committed to that task. So I just wanted to say thank you. We appreciate your service. We have a few questions. We'll start off with Assemblywoman Black, please.
Mr. Chair, and thank you, Mr. Attorney General. My question is relating to the opioid crisis. According to an article in the New York Times on February 3rd of this year, 49 of 50 states have settled with McKinsey and Company for their role in the opioid crisis, which, with myself included, affects a lot of our lives. In addition to the 49 states, Washington, D.C., and 5 territories are settled. Could you explain to this committee why Nevada is the only state in the nation that did not settle this portion of our case? And do you know something about it that we do not, or that other states do not?
Absolutely. And Assemblywoman Black, great to meet you. I think I saw you at a restaurant recently, and my apologies for not recognizing you and properly greeting you. So it's great to see you, great to meet you, and congratulations on your win. Let me take the second part of your question first. Yes, I know something about this case that you don't, and that other states do not. And that is our state law is a lot more favorable for us being able to protect, and provide abatement services to our citizenry, to our residents, those who have been gravely affected by the opioid crisis. We are still in conversations with McKinsey on this issue, but what we would not do is take an amount that was insufficient to address issues that were probably caused partially by McKinsey. So stay tuned, Assemblywoman Black, in that regard. If we are able to come to an settlement, we will do so. If not, we have a lawsuit pending that will be including them, and we will be recovering after we win that lawsuit. I am entirely confident on that. So hopefully that answers your question. But again, stay tuned.
Next, we have Assemblyman Matthews, please.
Thank you, Mr. Chairman. Attorney General Ford, good morning. Thank you so much for your presentation and for being with us here today. I had a question regarding the Office of Military Legal Assistance. I'm glad to see you continue that program, and glad to know that Mr. Dana is continuing to work hard in that role. I know that one of the challenges that comes up often with our veterans community is information on how to gain access to some of the services that are offered to them. I'm wondering what systems are in place in your office to make sure that our veterans are aware of OMLA, that they know how to access those services. Is this something that you do in conjunction with the Office or the Department of Veterans Services? I'm just kind of wondering what kind of communications apparatus you have in place to make sure that our veterans know about this program. Thank you.
Yeah, my pleasure. And great to see you again, Mr. Matthews. I think you and I used to correspond quite frequently when I was in the Senate and you were over at NPRI. Great to see you. Congratulations to you on your win as well. I'm going to elicit some support for this answer she's raising her hand right now. I will say briefly, though, that absolutely we have partnerships throughout the entirety of our state with veteran-based organizations, other pro bono-based organizations, and we do our own advertising. And Mr. Dana, who still serves our country in the military, is great in this particular arena. But Jessica Adair, my chief of staff, can offer some more insight.
Thank you for the question, Assemblyman. Jessica Adair, for the record. I'm so glad you asked this because I love to talk about the Office of Military Legal Assistance. It's one of my favorite programs in this office. I'm really proud of Special Assistant Nick Dana, as well as our program manager, Brian McDonald, who have done yeoman's work developing this program and expanding it. So one of the exciting things that they did prior to COVID was develop a partnership with the Department of Veterans Services and with the VA specifically. So when they have quarterly clinics where they go to the VAs where the veterans are already receiving services, they set up tables and a partnership with the Department of Veterans Services. They set up essentially fairs where people can come get information about a variety of services. So not just pro bono legal assistance from the OMLA, but our Bureau of Consumer Protection attends. Oftentimes veterans are victims of scams specific to veterans and military families, as well as other healthcare assistance, financial assistance, housing assistance, et cetera. So it's a really exciting program because they have been able to work with the community, the veterans community here in Nevada and federally to get all of those services to the veterans. In terms of public outreach, we work with our communications department as well as local media to advertise those clinics. And then we're always available by phone. If anybody has a question of our OMLA, they can call our OMLA staff directly, and they will connect them with pro bono legal assistance or provide that legal assistance, or offer a referral to resources that they may need that aren't necessarily legal assistance related.
Thank you to you both, and thank you, Mr. Attorney General, for your kind words. I appreciate that. Thanks, Mr. Chairman.
Thank you, Assemblyman. Next, we'll go to our Madam Vice Chair.
Thank you, Chair. Thank you to the Attorney General's office and your team for doing the presentation today. It's always a pleasure to see you and to continue to work together towards creating a better Nevada. I'm just wondering if you could talk a little bit more about the allocation of the VAWA, SASP, and the STOP grant funds, and talk a little bit about how much of that is going into victim services.
Mucho gusto en verte, Assemblywoman Torres. So thank you. Good to see you, ma'am, and thank you so much for the greeting. I'm going to turn the mic back to Jessica Adair to answer that question as well.
Thank you, Assemblywoman Jessica Adair, for the record. I'm glad you asked this question, and this is another one of my favorite things to talk about. And I know that your attaché has been in touch with our grants manager on this program specifically. So our office is the statewide administrator for VAWA, or Victims Violence Against Women Act funding. It's a federal program grant. So the way that is different from a grant in which our office has to apply for and be awarded funding. We are awarded this funding every year so long as the state of Nevada is meeting the terms of the grant, like every other state. And that allocation is essentially population-based from the federal government. So once we receive our notification from the federal government that we have received that program grant every year, there's two different kinds of funding from VAWA. As you indicated, it's STOP and SASP. STOP is dedicated towards domestic violence funding, and SASP is dedicated to sexual assault funding. Each of those grants is a little bit different in terms of their terms and conditions, as well as a specified amount that has to be given to different categories of grantees, and that is determined by the federal government. So once we get that amount, we put up a notice of solicitation. We announce that publicly through a press release, and we also will advise service providers and law enforcement agencies across the state. So there is a specific set aside for STOP, specifically for law enforcement agencies, that they have to be awarded that percentage of the grant. So after we put out the solicitation, we receive the applications. We also do webinars, so our grantees are successful, or our applicants are successful. These federal grants, as you can imagine, are very tedious and cumbersome applications. So we do those webinars so that they understand what a successful application looks like. Once we get all those applications, we have a committee that we put together of folks who are knowledgeable on these issues, and that committee meets for about 2 days, and we review all of the applications, and using a scoring mechanism from the federal government, we score all of the applications, and then after that, we make determinations as to who has submitted successful applications, and within the parameters set by the federal government, how much money can we distribute. I will note that for both STOP and SASP, it is intended to be seed grant funding. So a big part of those applications is, can a grantee show that they're able to continue a sustainable funding mechanism beyond the life of that grant? Which frankly can be very difficult for grantees when they receive some funding for 1 year and then they have to go somewhere else to continue funding that program. I'm happy to send you more information about that solicitation. I believe it is in March that we are going to be putting that out. I was very happy to be part of the committee that reviewed those grants last go around, and it's a fantastic program, and particularly for the state of Nevada. where we have such high rates of domestic violence on the STOP program specifically. And our service providers and law enforcement agencies across the state are really doing some incredibly groundbreaking work on these subjects. So it's really exciting to be able to fund that work.
Thank you. I would really appreciate that information at your convenience.
And thank you, Madam Vice Chair. Next, we can go to Assemblywoman Brown May.
Thank you, Chair. I appreciate the opportunity. Thank you, Attorney General Ford, for your presentation. We really appreciate all of the wonderful efforts that you and your team have done throughout this very trying last year in particular. My question is relative to consumer protection and how it relates to eviction efforts, right? So many of the residents in Assembly District 42 that I represent are really concerned about this issue. And I know that you've been very robust in responding to eviction protections. And I'm curious to know if you could share with us your philosophy and perhaps some of the great results that we can look forward to in the future, as well as what you've accomplished today.
Yeah, congratulations, Assemblywoman Brown May, on your appointment. Looking forward to working with you. When I was in the State Senate, Assembly District 42 was the northern part of District 11. And so I'm very familiar with that district and that area, and very in good hands with you. So thank you so much for your service. I'm going to answer that briefly, but I'm going to offer my second assistant, Christine Jones-Brady, the opportunity to add more because she oversees that division. We were busy. We were very busy, especially at the outset of COVID when the governor issued his eviction moratorium. We fielded tons of questions from apartment complexes that didn't understand, some that did understand but wanted to break the rules, and then also from landlords and tenants who were looking to try to find ways to work together. We kept a lot of people in their homes. It was hard to stay home for Nevada if you had no home to stay in. And so the eviction moratorium was a very big component of what our Consumer Protection Division had to oversee. Let me offer Christine Jones-Brady an opportunity to offer a few more comments on that.
Thank you, Carol. Thank you, Chair. With the consumer protections role in that, one of the things we did, as General Ford just indicated, was field a lot of calls. Our lines remained open to talk to people during this time. And our main goal initially was as support to local law enforcement and local communities who were dealing directly with people who were objecting to either their eviction or landlords who were trying to evict someone who maybe was breaking the law. So there was a balancing act that we did, or a test where we would literally, our goal was not to arrest people, not to throw landlords in jail or anything like that. Our goal was to serve as a community liaison, prosecute if we needed, and I think we came away with 1 or 2 prosecutions of illegal evictions, but mostly we were trying to prevent evictions and encourage the landlords and the tenants to work together with law enforcement to make sure that people were able to remain in their homes during a very contagious period of COVID.
Yeah, and I will wrap up this answer by also indicating that we gave $2 million of settlement funds for emergency rental assistance, try to help people during this time period. And we also put out information in English and Spanish to try to help folks, and when we get translations into other main languages in our state as well, we were trying to do that as well. So we were actively involved and engaged in trying to help folks with the eviction issues, and we remained engaged at some level, although now it's more of a federal issue than it is for our state. So hopefully that answers your question, Assemblywoman Brown May.
And thank you, Assemblywoman, for that question. I think there isn't a member on this panel who didn't have the opportunity to hear from both sides of that conversation, how it was so difficult for us to have to ensure Nevadans could stay home, and at the same time making sure that landlords were not in a financial situation where they were at risk of a whole host of things. And I think we still see some of that manifesting now, and we'll see it manifest later. So I think it's a hard line to walk, but we're doing the best we can. Next, I'd like to go, and Assemblyman Ellison, I was going to go to you, and I apologize. I accidentally skipped over Assemblywoman Anderson. So I'll go to Assemblywoman Anderson, and then I'll come back to you, Assemblyman. Assemblywoman Anderson, please.
Sorry about that. It was quite all right. Good morning, Attorney General Ford. It's always nice to see you. Quick question. I actually have two. First of all, I'm one of those weirdos that really enjoyed reading the whole policy book. Great information on it. The first question, though, I had has to do with page 19 with the housing, where you stated that, or the office stated that it looks like there's going to be some more housing issues coming up with mortgage. It looks like some possible other sort of litigation around that. Can you expand upon that, or is that something that's going to be coming in attractions, and you just wanted to let us know that it could be coming up a little bit more?
Well, first off, congratulations to you. I almost called you by your first name, Madam Assemblywoman, but congratulations. We've been friends for a while, and I'm happy to see you serving our state in this way. I think this was predominantly a warning to let you know that this is coming. Helping to draft this was Jessica Adair, but also involved in this conversation was Christine Jones-Brady. I want to give them the opportunity if they want to chime in here with a response.
Some of those, thank you.
Christine Jones-Brady for the record.
For the record. Some of those numbers are estimates that are based relative to unemployment rate. So there are some calculations that the division was able to make that if there were so many people who have lost their jobs, then they could anticipate a certain number that would be at risk of losing their housing.
Thank you. That totally makes sense to me. And then the second question has to do with the COVID-19 responses. I just wanted to bring up how much I appreciated the work that you all did on open meeting laws and allowing that to be done virtually. Do you think that there's going to be some possible long-term changes that need to be made for open meeting laws because of some lessons learned from this and allow for more accessibility for possibly doing more testimony via Zoom, et cetera? Or do you feel that the current language is appropriate?
Well, I appreciate that. I'm going to preface Kyle George's response, who oversees, and also Jessica Adair's response, who work in this area as well. I will say this, as a general matter, COVID has taught us a few things about being efficient and being effective while having to work from home. And we have had to do that. We remain essential to the assistance of Nevadans. And the open meetings law work that we did with the governor's office and others to ensure that the state's work could continue with a level of transparency was important in that regard. So let me let my Southern team speak up on this real quickly.
Thank you, AG Ford. Thank you, Assemblywoman Jessica Adair, for the record. And I worked closely with First Assistant Kyle George on this issue. And I don't want to steal the thunder of one of your fellow committee members who we've been working with on this issue in particular and a possible legislative solution. One of the things that we learned in terms of, like AG Ford mentioned, how we can do better is increasing transparency in the government by using virtual technology so that more people can participate in public meetings. So it is, we field many complaints when we have public bodies that meet in one physical location. Most of the state can't travel to attend that physical meeting. There isn't a means to attend virtually or telephonically. And sometimes that meeting happens at a time that's quite inconvenient for most of the public, either during the day or sometimes in the evening. If a person has children, they have to find childcare in order to attend that meeting. So we've actually had a really great experience with these public meetings meeting virtually. Though we want to ensure that even though we have virtual meetings, that there is a mechanism for those who don't have internet access to make sure that they can still participate in those meetings, for one. And two, that we have a mechanism to ensure public comment. That was one thing that public bodies had to figure out how to deal with at the beginning of the pandemic, especially when we didn't have the technology that would accept public comment. I think the experience that we have right now in this legislative hearing is one that shows that we actually can use technology in a way that allows public participation, and anyone can watch from home or from work without having to travel to a remote part of the state that might be for them if they live in Eastern Nevada, for example. So thank you so much for that question, and we look forward to working with you and your committee on this issue in the future.
Thank you so much, and thank you, Mr. Chair.
Thank you, Assemblywoman. And for our final question, we have Assemblyman Ellison, please.
Thank you, Mr. Chairman. And Mr. Ford, thank you for putting on the presentation. I know you've worked really hard with a lot of these programs, and you know, and I was on one or two of them. But can you tell us what's going to go on in the future with, you know, these people that are you know, going after children and God, I'm trying to think of the word. I lost it in my head. But what they're doing is, you know, the truckers were helping, you were helping, and all these people trying to stop this from gathering these children up and moving them out of the country or wherever. Could you answer that?
Senator Nelson, great to see you. I hate that I didn't get to make it out to Elko for Cowboy Poetry this year, but I look forward to getting back up there and saying hi to you. I think I understand your question. I believe you're asking about human trafficking. Is that right?
Yes, sir, I am. Sorry, I got one of them headaches today. But yes, and you know, we talked about that several times about the human trafficking and what they were doing. And I know that there's a lot of people worked on this, but you kind of seem to taken this very personal and was following it really well. Can you tell us where you're going to go from here?
I can offer some insight into that. Yes, I'll also pick on Jessica Adair, who's intimately engaged and involved in that area as well. We have a criminal prosecutor here who works in specifically child exploitation issues, and to the extent there's overlap with sex trafficking, human trafficking, and children, she's actively engaged in that. We have an ombudsman officer as well that works, as I've indicated, not just on domestic violence, but on human and sex trafficking as well. I literally, I believe it was yesterday, 2 days ago, filmed another PSA working with, these are beer wholesalers, and we are going to be putting out another PSA about how they can help us to spot human trafficking going on in the areas in which they walk. Last week, I did a PSA with Uber talking about sex trafficking so that they could see and be able to report instances when they see it going on. The truckers, as you've indicated, I haven't worked with them as of late, but we've worked with them in the past to put on information and as much as we could to help bring shed some light on the fact that it's taking place and to let people know what the warning signs look like. I've spoken to children, youth groups on this issue. And you are right. We are intimately, actively involved in trying to eradicate human and sex trafficking. And unfortunately, Nevada remains at the top of the list when it comes to that. I had a conversation, and I will keep it to myself relative to with whom, but we are looking for other local law enforcement to engage with community partnerships to affect this and address this as well. So that's what the future looks like. We will continue moving forward on trying to prosecute these cases, on trying to work on what we call the demand side of this, dealing with pimps who oftentimes help feed into the human trafficking side of things, and ensuring that we vigorously enforce the law in that particular arena. I have Jessica Adair, who works with our ombudsman. I have Christine Jones-Brady, who works with our prosecutors, and I'm going to give them both the ability to chime in if they'd like to. You don't have to, but I want to give you the opportunity.
Follow up, if I may, sir.
Oh,
and
sure.
then one question maybe before I get this other answer. Is there a way to increase the penalties for these that are caught, exploiting children and women? Is there any way to increase these penalties to where maybe this, you might think twice before they do this?
Well, I'm just going to answer that real briefly and say that's on y'all. That's on the legislature to make a determination in that regard. I will say that there is a general consensus that these folks need to be punished and they need to be dealt with. So to the extent there's an appetite for it, we can absolutely engage in that conversation around that. I believe that we have bills that may attempt to do some of that as well. But that's a great question. And again, let Jessica and CJ chime in. And y'all can address both of those.
Thank you, AG Ford. Jessica Adair, Chief of Staff for the record. So to the latter part of your question, we did have a bill last year that this legislative body passed that strengthened laws that dealt with the solicitation of children specifically. So we were really excited to work with the legislature last year on that issue. If you have another bill that addresses those subjects, we'd be happy to talk to you about that. So part of one of the best parts of my job is working with our Ombudsman for Domestic Violence, Human Trafficking, and Sexual Assault, Nicole Riley. She is working very diligently across the state on this issue. The fact of the matter is that most trafficking occurs in our backyard, and most traffickers are those who are in our neighbors, unfortunately. So that's really what we need to focus on. And when AG Ford talks about focusing on the demand side, that's one thing that Nicole and local law enforcement agencies have been working on. And what we mean by that is we're focusing on the buyers, those who are seeking children. And how we do that is through sting operations that, thanks to the bill that we passed last year, we're able to do with online advertisements. So we don't have to use any actual human child in order to do these sting operations. So a law enforcement officer will post an advertisement. A person seeking that advertisement will show up at a house and they're arrested. So they have a wonderful operation up in Northern Nevada with the HEAT, H-E-A-T team, and our office is part of that task force. I believe they picked up 28 folks last fall who were specifically seeking children in Northern Nevada. And we're trying to expand that area where we have that task force to bring in other local law enforcement agencies. And of course, public information and outreach is a big part. So when people see signs of trafficking, something that doesn't quite look right, they know what to do and they know who to call. So that is a huge priority of this office. And then finally, in 2019, our ombudsman, working with other national groups on this issue, put together a law enforcement summit on human trafficking issues, human trafficking investigations. We did that summit here in Las Vegas, and then we did the same summit up north so that folks up north could attend. And that was post-certified, so law enforcement officers could get some continuing education through post credits. And it was a wonderful opportunity to start that conversation or continue that conversation with experts in this field. There are a lot of great law enforcement agencies who are working with us and victim service providers who are really interested in how we can continue to move this forward for the state.
Thank you very much. I think that's important, and I think the information we can get out to the public is important. Mr. Chairman, I don't know of any bills that are available out there. I don't know if we could find somebody with a committee bill that we could address this, but I think it's spreading dramatically across not only our state but the country. So it's something you might want to think about or know somebody that could help us do that. And thank you.
Yeah, the I-80 corridor has proven to be a problem for us in this particular arena. And so we are absolutely open to discussions around this issue. We will remain involved in it. In years past, we've worked with the Sam's Corporation, the Venetian, and they sponsored a conference for us or a gala and a fundraiser. COVID didn't allow us to do that this last year, but we intended to continue working with them on this going forward as well. So we welcome your help, Assemblyman. Thank you so much for the question, and I hope you feel better soon.
Oh, thank you.
And thank you, Assemblyman Ellison. I know that there's likely a place where we can all sit down and have a conversation about this here in the Nevada State Assembly. I'm sure that there'd be folk that'd be willing to work alongside of you. And Attorney General Ford, I wanted to say thank you as always. Welcome home. And you know you can always come back here. Members, I encourage you to be sure to reach out. Their office is incredibly accessible and they have a lot of information to share. This is just the beginning of the conversation. With that, I'd like to close out the hearing from our Attorney General. And again, thank you for being here. And next, I'd like to open up the presentation by the Office of the Labor Commissioner, Department of Business and Industry, Ms. Chambers. Welcome.
Good morning, Chairman Torres and members of the committee, Vice Chair Torres, sorry, Chairman Flores and Vice Chair Torres, I'll get that right. Congratulations to all the new committee members and happy to be here and happy to present for you. I'm going to actually share my screen here and go through some materials. So the Labor Commissioner, I'll just kind of, I know in the interest of time, there's a lot to cover with the Office of the Labor Commissioner. So there's some issues that I know typically come before government affairs that I'll kind of focus on, but wanted to give a big picture of our office and kind of what we do and how we do it. And so the Nevada Labor Commissioner is essentially responsible for all the wage and hour laws in the state of Nevada. So we kind of basically enforce all the overtime, minimum wage, employment practices laws, and then we also have kind of a carve out for breaks and lunches, making sure that employers and employees are following the law in those areas. And then we also are responsible for paid leave in Nevada, which came about last session under Senate Bill 312. And I'll talk about that a little bit later. So we have 20 total staff. And just to give you a perspective, we have had 20 total staff since 1999. So we are a general fund agency, and that's one of the issues. We typically don't grow, but we always grow in responsibility. So obviously have to work through those issues and do what we can to maximize efficiencies and effectiveness in investigations. Any administrative penalties that we issue or any fines, we do not get to keep. So if there's a perception out there that we're going after employers and we're fining them to keep the penalties or the money, we don't. It all goes into the general fund. So just want to make sure that that's clear to everybody. So we have really three main responsibilities. We regulate private sector employment, and then the topic that I'll probably focus more today on in this committee is public works projects, prevailing wages on public works projects, and the Apprenticeship Utilization Act, which came into effect starting January 1st, 2020. We also regulate private employment agencies. So that's like your temporary agency, your labor max, your manpower. We also license them. So we have about 176 of those in the state right now, and that is an active area. I will tell you it's growing in the state of Nevada, and mainly in northern Nevada, with a lot of the giant warehouse companies and manufacturing companies moving to northern Nevada and out to the Tahoe Regional Industrial Complex, TRIC. So that is an active area, and again, we expect that to grow going forward. So I'm not going to go through each and every single one of these, but this will kind of give you a big idea of how much responsibility the Office of the Labor Commissioner has with 20 employees and 9 investigators across the entire state. We have a lot of statutory and regulatory responsibilities. The one thing that was taken away back in 2017 is apprenticeship. That is now under the Governor's Office of Workforce Innovation, called OWIN. They manage the State Apprenticeship Council, which moved to Owen in 2017. For the committee members that are not aware, there is a budget proposal to move Owen to the Department of Employment, Training, and Rehabilitation, so to move Owen to Dieter. So that is in play right now too. I will tell you there has been some talk about moving the State Apprenticeship Council back to the Labor Commissioner because of the Apprenticeship Utilization Act, and that might be something that gets discussed during this session. So I'll just kind of touch on these very quickly. An employer in the state of Nevada is essentially somebody that has control or custody, governs the place of employment, the type of employment over an employee. An employee is essentially somebody that is under that control and custody and is working at that location. Independent contractors and how independent contractors are treated and whether they should be employees is a huge topic. It's been a huge topic for decades, and the past 4 or 5 years, it's been an even bigger topic. So last session, the Nevada Legislature passed Senate Bill 493, which created the Task Force on Employee Misclassification. We are now meeting and are going to develop basically a report to the Nevada Legislature that did kind of get delayed from last session due to COVID, but that now is in effect and we are meeting. The federal government, so the United States Department of Labor, I was on a call yesterday. They are transitioning now to a new presidential administration. That transition's already happened, but obviously they have to fill the cabinet positions. There is a new Secretary of Labor that's going to come on board, Mr. Walsh, and they have already stopped kind of some of the Trump administration's opinion letters, not only on independent contractors, but also on some of the issues involving tips. So what I would kind of say about this issue is stay tuned, and the Labor Commissioner will continue to follow it. This definition, however, is valid law, what you're looking at right here. And the Labor Commissioner does use this definition along with the other legal guidance from not only the state side and federal side, but essentially an independent contractor is somebody who works for a person and performs a service for a fee, but can basically kind of govern when they work, how they work, the methods they work. And I'm simplifying here, but this issue is a huge issue and probably could take up a whole hour. So just definitely wanted to bring it to your attention. California passed Assembly Bill 5 a couple years ago in an attempt to make individuals like Uber drivers and DoorDash drivers employees. Proposition 22 was put on the ballot last year, and the California voters actually voted that down. So again, just wanted to point that out and make sure that you're all aware of that. And again, we'll continue to follow that from the Labor Commissioner's office. So minimum wage in Nevada, another big topic, and it's now a topic at the federal level, and I'll kind of go through this very, very quickly. Prior to Assembly Bill 456, which passed in 2019, the minimum wage in Nevada was set forth in the Nevada Constitution, and it still is. So AB 456 and the Nevada Constitution work together. There is what's called the two-tier system. So if you're offered health insurance, you can pay the lower rate. If you're not offered health insurance, you have to pay the higher rate. You cannot use, an employer cannot use tips to offset any of those amounts. So unlike a lot of other states and federal law in Nevada, any employee that receives tips, those tips cannot be used to offset the minimum wage. Senate Bill 192 last session did define what type of qualified health insurance had to be offered or made available. So there's very specific requirements that an employer has to follow when they're offering or making that health insurance available in order to pay that lower rate. Also want to make it very clear that all the employer has to do is offer. They do not have to provide the actual insurance. There was a case back in 2016, the Hancock case, that was decided by the Nevada Supreme Court that said all the employer had to do to meet the intent of the Constitution and now meet the intent of Assembly Bill 456 is offer qualified health insurance. So the other issue that Assembly Bill 456 took care of was there were some exemptions to the minimum wage that were put in statute by the Nevada Legislature. The yellow cab case said, no, you cannot have any exemptions to the minimum wage in statute. The only valid exemptions are those in the Constitution. So that's a worker under the age of 18, workers employed by a nonprofit for after school or summer employment, or a trainee. There is also an exemption for collective bargaining agreements. Typically, a collective bargaining agreement has a higher minimum wage rate anyway. So that's kind of why there's that exception to minimum wage in the Constitution. So this is what Nevada's minimum wage looks like right now as of 2020. The new rate will go into effect July 1st, 2021. And then as you can see, it will go up each July. So the Labor Commissioner publishes a bulletin every April telling Nevada employers the rate's going to go up in July. Here's exactly what it's going to be. So we will start that process again this April and notify Nevada employers of what the increase is going to be. We will also be watching the federal side of things. Part of the Biden stimulus plan is a potential increase in the minimum wage. So we will watch that and see what ultimately gets passed and how that may impact these rates. The language in the Constitution talks about if the federal rate goes higher than the current state rate, then the federal rate would be what is applied. So again, we'll continue to watch that issue. Nevada is also very unique, and I hate to keep using that term, but we are. Our minimum wage is tied to daily overtime. So we have this formula in Nevada in statute that says if you are basically making 1.5 times less than the minimum wage, you qualify for what's called daily overtime. So that's for work over 8 hours in a 24-hour period. So there is a lot of clarification that we have to give employers on this issue, because the federal standard for overtime in most of the other states is over 40 hours in a week. Nevada, again, with this unique over 8 hours in a 24-hour period, we do sit down with employers and go through their schedules and explain to them, depending upon if you're offering health insurance or not offering health insurance, if your employee's making less than $12 per hour or making less than $13.50, if they work more than 8 hours in a 24-hour period, you may have to pay daily overtime. I will tell you, since I've been the labor commissioner and going back to 2015, there has been discussion about potentially revising or eliminating the daily overtime requirement in Nevada. The last bill that tried to do that was back in 2015, was Senate Bill 193, and that ultimately did not pass. But again, just want to bring that to all of your attention. 410 exemption, we do allow that as long as employers and employees work a consistent 410 schedule. That is absolutely allowed. And I can tell you that with the COVID-19 public health crisis, we're seeing a lot more of the 410 schedules and a lot more of the flexible 312 type of schedules. And the labor commissioner does not have any issue with those types of things, as long as the employees are being paid what they're owed, and as long as overtime is being paid, depending upon if you're in the over 8 hour or over 40 hours in a week. So I'll kind of go through these fairly quickly to get into the public works side of things. So we also enforce many of the labor practices in the state of Nevada. So record keeping in Nevada, you have to keep basic records of employees and wage data for 2 years. There have been previous proposals to increase that to 5 years. That has not happened, so it is still 2 years. We also enforce deductions in the state of Nevada. Nevada has a very kind of strict requirement that you cannot take a deduction out of an employee's paycheck unless it's for a specific pay period, purpose, and amount. So the term blanket deduction doesn't work in Nevada. Now, that's not to say that if you have insurance deductions or child care that you owe, child support, we will allow, a court order or some type of an official document so that an employer doesn't have to do that every single paycheck. But the goal of this provision is so that employees know exactly kind of what's coming out of their paycheck. So breaks and lunches, again, we enforce breaks and lunches in the state of Nevada. Employers can request a waiver of breaks and lunches as long as it's in writing and the employees agree to it. And we do grant those. And I will tell you, in the time of COVID, we are seeing a lot more requests to waive breaks and lunches. People either want to work and get home, or they want to pick up more hours. So we are more than willing to look at those requests and to grant exemptions when it's appropriate. In Nevada, if you are terminated by the employer has to issue your paycheck within 3 business days. If you resign or quit, basically, it has to be issued within 7 business days. So I will tell you that in COVID, and I hate to keep bringing this up, we are seeing a lot of issues with employers terminating employees and the paychecks not being issued within that 3 business days. So we obviously try and work with employers. Some of them are having valid financial issues. Some just sometimes don't quite know what they need to do. And so we try and do as much education as we can and make sure that they do comply with those requirements. We do also enforce the semi-monthly payday. So we are seeing some delays in that as well. Again, you know, businesses and companies that went from being open to being shut down to being open again to being at 25%. So again, we try and work through those issues with employers, try to make sure that they absolutely follow the law, but certainly also do understand that there are definitely some financial considerations sometimes that go into what's going on here and businesses reopening and shutting down. So just to kind of give you a perspective of last session, and this is not all of them. So these were all the kind of labor and paid leave bills that impacted the labor commissioner last session. So paid leave in Nevada, starting last January 1, 2020, employers in the state of Nevada with 50 or more employees now have to provide paid leave. And just to make it clear, it is not paid sick leave. It is called paid leave in the statute. It started out as a paid sick leave bill, and ultimately when it was passed, ended up as a paid leave bill. So just want to make that clear. A lot of people still think it's a paid sick leave bill. It is not. It is a paid leave bill. That bill did provide some exemptions for employers that were already providing paid leave that met the minimum requirements of the new law. So there was some trade-off there, but obviously paid leave is a big topic. And on the federal side, potential new emergency federal paid sick leave. The previous emergency paid sick leave under the federal side, the Families First Coronavirus Response Act, expired December 31st, 2020. Employers can still do that. It's optional, but again, the labor commissioner is going to keep watching that issue and see where that goes. The marijuana testing bill, we essentially took over enforcement of that bill. That has to do with certain positions and whether an employee can be denied employment for testing positive for marijuana. Again, it depends on the position and whether it's a safety position or operating equipment, but we have enforced that bill and we've had around 10 complaints involving that bill that we have resolved. For the committee's knowledge. Reporting sick time, this was a bill that basically said if you call in sick to your employer, they can't make you come to the office to prove you're sick. And that's really all I'm going to say about that bill. I talked about Assembly Bill 456 and the increase to the minimum wage. There's also a joint resolution that's still out there to increase the minimum wage that could be essentially passed in 24 and put to a vote of the Nevada voters. Senate Bill 192, I mentioned that was the requirements for qualified health benefits. And then the Employee Misclassification Task Force, that was Senate Bill 493. So as I said, we had our first meeting January 25th. That actual commission or task force did not get appointed until the beginning of November. Again, a lot of things just got delayed because of COVID, but we are meeting and we're going to be meeting again at the end of February. So bulletins and guides, the labor commissioner is required by law to publish many different bulletins and guides for Nevada employers. We also expand upon that in a voluntary way to provide employers with guidance and information. And we do a lot of outreach. I will tell you that we probably pre-COVID, we're doing 30 to 40 seminars every fiscal year or every year. We're still doing those online, but we find that due to our kind of staffing levels, that the more education we can do up front, that helps us in terms of not getting as many claims and complaints. And again, just providing Nevada employers with all the good information, because there's a lot of new employers in the state of Nevada and a lot of new employers from outside the state. So these are our required postings, and every single session since I've been labor commissioner since 2014, we get a new required bulletin, and we are more than happy to implement these requirements and to publish these bulletins, but this gives you an outline of kind of every single required bulletin that an employer is required to post in their office for Nevada employees. We've been getting a lot of interesting questions from employers because of COVID, that because people are not coming into the office, where can I post these? And, you know, where can I send these to my employee who's teleworking or who's not coming into our office every day? And the guidance we provided is send these all as a link, and we have those links. Have a form that the employee signs so they acknowledge that they have seen these and that they've been posted, and we work through that, and that seems to be working very, very well. So what happens when a claim and complaint is filed? I'm not going to go through the whole process just in the interest of time, but the labor commissioner is absolutely bound by law to provide the employee with a right to file a wage claim, the employer to respond to that wage claim. An investigation then takes place. A determination gets issued. Both parties then have the right to respond to that determination. Depending upon how that process goes, the claim can get resolved very, very quickly, or the claim can go on sometimes to an actual hearing before the labor commissioner. That is rare, I will tell you, in your typical minimum wage or overtime case. Typically what happens, employers either realize they made a mistake, or the employee realizes that they made a mistake and the issue is able to be resolved and the employee gets paid and the matter's resolved, and it kind of stops there. But I just want to make clear that there is an absolute process to all of this, and the labor commissioner does not have any authority to shut a business down. And believe me, I get that all the time. Why can't you go out there and just shut them down? Why can't you, take their license? The labor commissioner does not have the authority to do that. We certainly report violations to the attorney general's office and to the district attorney's office, but under the labor commissioner, I do not have that authority. There was discussion of possibly providing additional authority to the labor commissioner to issue like a cease and desist if we had an employer where we had numerous wage claims or different things like that. That was discussed back in 2015. That kind of didn't go anywhere. But again, just wanted to make sure that the committee kind of knows what authority we have and what process we have to follow. So public works and prevailing wage, this is typically something that would be heard and seen in the Assembly Government Affairs Committee. And I've, since I've been labor commissioner, have done presentations for this committee on this topic and have tried to update the committee members on all the changes and laws. And every session, there are quite a few bills that impact public works and prevailing wage. And then starting last year, the Apprenticeship Utilization Act. So kind of to simplify it, every project currently in the state of Nevada that is over $100,000 that's funded with public funds is considered a public works project. In 2019, Assembly Bill 136 changed that amount back from $250,000 back to $100,000. They also included charter schools in the public works definition. So if there's a charter school and the project is over $100,000, it is now considered a public works project. And the public body, in the law, it's called the awarding body, who is actually building that project or awarding that project, has to obtain what's called a public work project number from the Nevada Labor Commissioner. So I am aware that there is a bill out there right now, Assembly Bill 99, to potentially change the public works project amount. That is an area each session that I've been the labor commissioner. Some people wanted to go higher, some people wanted to go lower. So again, we adjust based on what gets passed by the legislature. The awarding body also has the duty to bid the project and use the prevailing wage rates that are in effect at the time that the project is open for bids. So the Nevada Labor Commissioner calculates those prevailing wage rates. The public body has to award the project using those rates, and then essentially they award the project, it gets awarded. The contractors and subcontractors that are working on that project then have to file what are called certified payroll reports. And what they're certifying is that they are working on this project, that they are paying the correct prevailing wage rate for that particular job classification. They certify that under penalty of perjury. That gets submitted to the awarding body. And in a typical situation, the project gets built, the issues are none, and everything goes fine. In the case where things don't go right and contractors, subcontractors, or awarding bodies don't follow the law, then it becomes a potential investigation before the Nevada Labor Commissioner or a potential investigation before that awarding body. So there's kind of two tracks that can take. But I want to tell you that as the Labor Commissioner, at least 90% of public works projects go just fine with no issues. The law is followed and the schools get built or the road gets built and everything is fine. It's that 10% that causes a lot of issues and a lot of potential problems. So contractors, again, if you're working on a public works project, you have to follow public works laws. You have to pay the applicable prevailing wage rate for that job classification and for that employee. So one of the issues that we see on public works projects and where a lot of the claims and complaints come from is potential misclassification of workers. So you may have a project, and I'll just use this example because it's a valid example in a public project and public record. There was a project where it was all vertical construction. So think of building a building going upwards. And they were building a steel building, and all the work that they were doing, well, at least 99% of it was iron worker work. And so when the awarding body actually went to look at the certified payroll reports, they discovered that everybody was being paid as a laborer and not as an iron worker. So that turned into an investigation that came to our office. And obviously we go after the back wages, and then we have the ability to potentially issue any penalties. And worst case scenario, we can actually disqualify a contractor from working on a public works project. First violation, 3 years, second violation, 5 years. In the past year, we disqualified 5 contractors, and we do not take that decision lightly. It is typically something where we're looking at a contractor who has maybe had a violation several times or is actually doing something very, very intentional to try and get around the law. What's interesting about how claims and complaints come into our office is they can come in through the unions or trade organizations. They can also come from other contractors. And that is the majority of complaints that we get is from other contractors who are complaining about another contractor who's not following the law. So it's always interesting, and that's just part of the process. The key point I want to highlight kind of here too, and we definitely have this conversation with the prime and general contractors, is under Nevada law, if you have a subcontractor that doesn't pay their employees or doesn't pay them properly, then ultimately that prime or general, or what the law says, the original contractor could be liable for all of those things. So we really emphasize to contractors, know who your subcontractors are and know what they're doing, because this can really put a contractor in a bad situation. So prevailing wage, we calculate that under the Office of the Labor Commissioner. Senate Bill 243 that was passed in 2019 changed that process a little bit. So we used to do it county by county by county. And what was happening was, depending upon the survey process, we were getting comments from a lot of the smaller counties that they were having to use the rate from Washoe County or use the rate from Clark County. So Senate Bill 243 changed that process and established what are called now 4 prevailing wage regions. So you have 2 urban regions, Clark County and Washoe County. Then you have what they call the Northern Nevada Rural Region, which is all the other counties in Northern Nevada. And then you have the Southern Nevada rural region, which is all the other counties down in Southern Nevada. The other thing that was changed is we don't calculate prevailing wage every year. We now calculate it every other year. So we calculated it in 2019. We will now calculate it again in 2021, and we do that through a survey process. We moved the survey process online starting in 2015. I sought some funding from the Nevada Legislature to make that process an online process, and that was approved. So just for perspective, by having the online survey process, we've gone from around 700 surveys during the prevailing wage survey to over 1,500. So more contractors are participating, more awarding bodies are participating, and that kind of helps balance out the rates. So again, we'll calculate those new rates in 2021. The school project rate, that is gone. That happened back in 2015, where there was basically a 10% reduction in the prevailing wage rate on school projects. That was eliminated pursuant to Assembly Bill 136. I mentioned the charter schools. They are now considered subject to public works laws if it's over $100,000. And now there's an adjustment if a project goes over 36 months. Then an adjustment has to be made to determine if higher prevailing wage rates need to be part of a change order because the project's gone over 36 months, or what needs to happen. So again, a lot of activity on the public works side, and there always is. And last session, a lot of changes, again, to bring that public works project amount back to 100,000, bring in the charter schools, and then now change how we calculate prevailing wage. So who is required to be paid the prevailing wage rate? So essentially it's anybody that's employed at the site of the project, that's necessary in the work of the project, and then that's actually at the site of the work of the project. One of the issues we have, and there's a case going on right now, is we occasionally will have a contractor that will set up like a work yard or something off just like 10 feet away from the actual public work project, and then say that they're not going to pay prevailing wage while the workers working at kind of that site because it's actually not on the project. What the law says, if you establish anything specifically, like a tool yard, a batch plant, a borrow pit, or any location that's established specifically for that public works project, you have to pay prevailing wage basically when that work is performed on that location. So we do have a case right now that's going up to the Nevada Supreme Court on that very issue, and we'll have to see what happens there. The Labor Commissioner did pass a regulation package last year that talks about service providers, and this is the best way I can describe it. If you are like a Sandy Hut driver and you drive on the project and you drop off a Sandy Hut and you drive off, that is not what prevailing wage is intended to cover. So the Labor Commissioner specifically excluded those types of things and called them service providers. I will tell you though, there was a bill last session, Senate Bill 340, that did attempt to subject deliveries on public works projects to prevailing wage. That did not pass, but again, just for reference, and the Labor Commissioner attempted to kind of clean up that issue and say, if you're truly a service provider, then you are not entitled to prevailing wage. So the other issue with prevailing wage in Nevada has a requirement that you can offset the prevailing wage if you provide bona fide fringe benefits. So I'll make it simple. So let's say the hourly rate is $40 an hour and you provide $10 in bona fide fringe benefits. You can take that $10 off of the hourly rate because you are providing a bona fide fringe benefit. Assembly Bill 190 passed last session defined what a bona fide fringe benefit was, because we had some situations where contractors were claiming bona fide fringe benefits, and we would do an investigation and we would find out that the benefits were not actually going to the employee. So Assembly Bill 190 attempted to define what a bona fide fringe benefit was. It also has an annualization requirement, meaning that you need to take out that bona fide fringe benefit the same every month. You can't just do it on one project and then not do it on another. So that went into effect July 1st of 2019. And we've done a lot of education and training on what is a bona fide fringe benefit and how you have to report it and what you have to do to annualize it. But Nevada absolutely allows an employer who is working on a public works project to claim bona fide fringe benefits. So apprentices, and I'll get into the Apprenticeship Utilization Act here pretty quickly. Apprentices do not have to be paid the applicable prevailing wage rate. The reason for that is because they are an apprentice, and the State Apprenticeship Council approves a specific rate for apprentices. So it may be 40% of what the journeyman makes, it may be 50%, depending upon what year of their apprenticeship they are in. But they are exempt from prevailing wage. The issue with apprentices is they do have to be registered in the state of Nevada. You can't just call somebody an apprentice or call them a trainee. They have to be registered with the State Apprenticeship Council. So we have had that issue with contractors who say, well, you know, they're an apprentice or they've been my apprentice for 5 years. And we say, well, are they registered? And they say no. We say, well, technically under Nevada law, they're not a registered apprentice. Again, the labor commissioner doesn't handle the registration of apprentices or the registration of programs, but we do have to verify that registration piece in terms of the exemption for prevailing wage. Design professionals are another exemption. That's not something we see a lot of. It's typically like your professional architects, land surveyors, and most of those people, I will tell you, are making more than prevailing wage anyway. So that's kind of an obvious exemption. I mentioned the service providers that we kind of took care of with the 2019 regulation package. And then there's different rates for a foreman, general foreman, and a journeyman on all these projects. So those are all set forth in our prevailing wage rates and all publicized so that everybody knows what they need to pay. So similar to kind of the complaint process for a wage and hour complaint, there is this very specific complaint process for public works complaints. The unions, trade organizations, contractors, basically anybody off the street has a right to file a complaint with the labor commissioner alleging violations of the public works and prevailing wage laws. So when we get those complaints, there's kind of two things we can do. We can investigate them ourselves, or according to the law, we can have the awarding body go out and do the initial investigation, and then we do kind of the follow-up investigation. What is unique about the labor commissioner as well is that we do have the ability to issue penalties against the awarding bodies. So if we find an awarding body is not following the law, the labor commissioner can conduct their own investigation and issue a penalty against an awarding body. And we have done that. It does not go over well, I will tell you, but I will give you an example of that. The bidding process on public works projects is a public and open process. We have had awarding bodies who try to award contracts as sole source contracts. So they may know a contractor, their brother-in-law may be the contractor. So they award the contract to one contractor and the other contractors don't get a chance to bid on that project. So a complaint instantly gets filed with our office and we do the investigation. And then depending upon the findings, we can issue an actual administrative penalty. So again, it goes through the process, investigation, determination. The parties have a right to file an objection. It can then go to a hearing, depending upon the decision of the labor commissioner. It can then go to judicial review. And if nobody likes that decision, it can go to the appellate court and then all the way to the Supreme Court. And these cases, typically, if it's a big complaint, they will go on for several years. And that's why we try and emphasize to everybody, the faster we can address issues while the project is ongoing, the better off it is for everybody. Because once we get in the court process, these cases, again, can take years to kind of resolve. And unfortunately, what happens when that happens is sometimes some of the workers are gone, sometimes some of the contractors are gone. So trying to kind of go back and fix things is not as easy as it could be if things were caught right up front. So Senate Bill 207, the Apprenticeship Utilization Act, which came into effect last January 1 of 2020. And I'll simplify this here because it's kind of small writing, but the concept of apprenticeship utilization has been around since I've been the labor commissioner, and trying to expand apprenticeship and get more apprentices on public works projects, and not just on public works projects, but to expand apprenticeship in general. So that has been a big topic. It was a big topic under the Trump administration. They issued what they called the apprenticeship expansion grants. Nevada did receive one of those. The labor commissioner didn't get any of that money, but it is a topic. So this has been around, like I said, since I've been the labor commissioner. In the 2019 session, the Apprenticeship Utilization Act was introduced. It went through various kind of conversations, various amendments. And so what kind of was finalized was, if you have a horizontal construction project, so think of a road, is the best way I can say it, for every job classification or craft on that project. So I'll use the simple example. If you have more than 3 laborers out there, then you're going to have 3% of those labor hours be worked by an apprentice. On vertical construction, it's 10%. So the way this law gets triggered is it has to be more than 3 workers of the same craft or type of work performed. So if you have less than 3, you are not subject to the Apprenticeship Utilization Act. It's more than 3. The issue then becomes, well, what does more than 3 mean? What if I have 4 different people out there during the scope of the project and there was never actually 3 at one time? That's not what 3 means. And I went back, and Chairman Flores, you were managing that committee. I went back and pulled the testimony about what does more than 3 mean. And the sponsor of the bill, Senator Brooks, said in his testimony, more than 3 is a crew of more than 3 for a specific period. So more than 1 day, a longer period of time. So the labor commissioners looking to minimal work or periods where there was never actually 4 out there. It has to be a crew of more than 3 who's consistently performing work out there day to day or week by week. I know that there are contractors and subcontractors who do not like some of the provisions of Senate Bill 207, and that there's not a fine point of, well, does it have to be more than 40 hours or can it be 20 hours? I certainly appreciate those comments, and that might be something going forward in regulation that we clarify. But the labor commissioner has really tried to put out a lot of guidance on this bill. We created all the forms for this bill. We created an entire website on this bill. I've issued 3 advisory opinions on this bill to really try and help contractors and subcontractors comply with this bill. The other unique feature of Senate Bill 207 is it has a waiver process. So a contractor can go to the awarding body and say, I can't get any apprentices in this jurisdiction, or there's no apprenticeship program in this jurisdiction, or I talked to the apprenticeship program and they told me that there are no apprentices that are available. So they can provide that information to the awarding body. The awarding body can then come to the labor commissioner, who can grant a waiver from the Apprenticeship Utilization Act to that contractor. So during 2020, we granted over 100 waivers from the Apprenticeship Utilization Act. Again, it could only be based on sufficient documentation, that a request was made, or that there simply were no apprenticeship programs within that jurisdiction. So we are granting waivers. We typically grant them within 24 hours. We want to make sure that these projects move along and that contractors and subcontractors know that they either need to comply with this or they don't. So that process does seem to be working well. We have not had one single denial of a waiver or the granting of a waiver. We have not had anybody appeal, which I consider to be a good thing. We really try to make sure that all the documentation's in line before we grant a waiver. But we are enforcing this bill, and we have had some complaints and claims where contractors have not complied with this bill at all and had more than 3 workers out there of the same craft for week upon week upon week. And then we get a complaint and we do the investigation, and then we take appropriate action after that. But this bill is a very busy bill for our office, between questions and waiver requests and then compliance questions. It is a busy bill, but we are managing it well. And like I said, I've really tried to reach out to the contractors and on all sides to try and make this work, and to work with the awarding bodies to really make this work as well. So just to kind of give you some statistics about our office. So the past 2 years, 2 fiscal years, from 18 to 20, we processed over 6,929 wage claims. We collected over $2 million. And then there was over $465,000 in penalties that went back to claimants on prevailing wage claims. So those are the public works projects claims. We had we had 170, collected about $700,000 in wages and $149,000 in penalties. Public works project numbers issued, over 1,500. I mentioned the Apprenticeship Utilization Act waivers. So I was going low, there was 148. The administrative penalties and fines, the 373,000 was a record for us. When I started as a labor commissioner in 2014, we were collecting 0. So all that money goes back to the general fund. And as I said earlier, we don't issue penalties and fines to have it come to our agency. It goes to the general fund. And anytime we do that, the employer always has the right to appeal that. Private employment agencies, 171, we are up to 176 now. And again, expect that to grow. Just to kind of give you a perspective on the employment numbers, and we get these from Dieter. So they are down on the private employment side by about 7.6%. On the construction side, about 7.4%. The belief is that is specifically tied to COVID-19, and that these numbers will go back up once we kind of get through that that whole issue. And I'm certainly not going to predict a timeline on that, but these are just kind of some numbers that I wanted to show you to kind of give you a perspective. The interesting thing about our office is as the economy grows, our wage claims go up. As the economy contracts, our wage claims go up. So it's an interesting dynamic, but that's just kind of something that happens with our office. So I'll go through these fairly quickly, Chairman Flores, just in the interest of time. So what have we done with COVID? We put out a lot of bulletins to Nevada employers, reminding them about Nevada employment laws and what they had to do. We've been doing a lot of outreach with the various employee organizations and employer organizations to try and jump on calls and answer questions. It has been a very busy time for us. I will tell you, just on the question side, we also did a reminder that Nevada employers had to follow Nevada labor laws, that we had no authority to suspend those. Now, having said that, we obviously were very, very reasonable and are still being very reasonable of timelines and people that either have had this COVID or know somebody or their business was closed. So we are granting extensions and trying to provide as much ability for all sides to participate in the process. Our claim filing is all online. Our records requests are all online. So we really have not slowed down in processing any claims. Our office under the governor's directive is not open to the public. However, We are scheduling by appointment meetings with claimants or employers, obviously with social distancing if we need to do that, but we have not stopped at all. And that has been very, very effective in our online filing. So we're up to over 85% of all our claims are filed online. So again, very proud of that. And we were kind of ahead of the curve on that. That went into effect back in 2015. So we issued a telework guide as well, because there's a lot of people teleworking now. I'm not going to go through each and every sentence here, but we did issue this, and this has been very good. Believe it or not, a lot of claims involving telework and things that employers did not think about as they had employees teleworking. And I'll give you a kind of an example. We had a wage claim come in saying that, you know, I'm having to print all these documents at home and I had to buy printer cartridges, and shouldn't the employer cover this? And I just bring that up as an example that that is something that employers and employees to re-engage in that employer-employee relationship and to talk about some of these issues, because a lot of this stuff is new, and the more employers have policies and procedures, the better off it is right up front. We also issued this guidance. There was kind of a trend happening for a while that as businesses were starting to reopen, they were asking employees to sign release of liability agreements. So saying that they wouldn't sue the employer if they got COVID-19, or they wouldn't sue the employer if they were exposed to it. There's still a lot of discussion about this issue. Obviously, there was some legislation passed during the second special session, Senate Bill 4, that did provide some liability protections for public accommodation facilities. But the bigger discussion of kind of entities that are outside of SB 4, this is the guidance that we put out, and the main one, and it's not under our jurisdiction, but you cannot require an employee to waive their right to workers' compensation. So that's very specific in Nevada law, but we continue to put out guidance and bulletins, and the most recent one, and it just was posted yesterday, is about leave for vaccines. So that is kind of the next evolution of all of this, is as the vaccines become available, the question for the employer is, are you going to require it? Are you not? If you're going to require it, you're pretty much going to have to provide some type of leave for the employee to get it. And if you're not, you still should have some type of a policy where you allow employees to either utilize leave or flex time to get the vaccines. But what I would say on that whole topic is there's going to be a lot more to come, probably not only at the state level, but also at the federal level. But just kind of wanted to point that out, that that's kind of the next step in the COVID guidance that's come from our office. So here's all our contact information, and I absolutely love interacting with, whether it's claimants, employers. The only time when I typically will not get involved is if there's an active claim or investigation where I may need to do the hearing. But I am more than accessible, so is my staff, and I would just say to any member on this committee, I'm more than happy to answer any questions and work with all of you. And thank you for the opportunity today. I mean, a lot of these topics, you could do an hour alone, but just kind of wanted to give you a big picture. And we do have a lot to do in our office, and enjoy doing it. But I really appreciate the opportunity, and I'm happy to answer any questions.
And thank you for that presentation, Commissioner Chambers. Before we start with our line of questioning, members, I want to set some parameters and preface it by saying, number one, this is not the only time we're going to have the commissioner here. We're going to have opportunities to speak with her, especially as bills are being presented that relate directly to her purview, number one. Number two, I also want to make it clear that she mentioned a host of bills that will be coming before this committee at some point. I ask that you refrain from asking questions relating to those committee bills. We'll have ample time to fully vet those once they come before us. And lastly, we have a lot of folk who intend to ask questions. So I ask that you try to limit them. I don't want to restrain you to one or two, just I ask that you try to limit your questions so that we get an opportunity for everybody to get them on the record. So we'll start off with Assemblywoman Anderson, please.
Thank you, and wow, Director Chambers, or Commissioner Chambers, excuse me, please get some water. That was a lengthy information. Quick question, it had to do with slide 6, excuse me. You mentioned the under 18 when it comes to the minimum wage items, but is there any other work that you do with the under 18s? One thing I realized or noticed as an educator, I was seeing more and more of our high school students being expected to work more than the 40 hours or 30 hours. I can never remember what the federal law states that if you're under 18, you can only work X amount of hours. So I didn't know if this department also was doing those investigations or working with that, or if it was others that were working on it for our under 18-year-old workers who are expected to work longer than the 30 hours as defined by the federal government.
So Assemblywoman Anderson, thank you for the question. Again, Shannon Chambers, Labor Commissioner for the record. So we do govern the employment of minors in Nevada, and in Nevada, you can work if you're 16 or older. However, you can only work in certain occupations, and I'm happy to have a follow-up discussion with you about that. But we started to see that issue with the schools being quote unquote closed and hybrid. And so we did actually work with the United States Department of Labor to put out some guidance to Nevada employers on that, you know, you still really need to follow not only their laws, but the Nevada labor laws when it comes to minors in employment. The other issue is a school that is hybrid is open. So the law specifically talks about in Nevada that if a school is open and the child is working more than 40 hours a week, that you have to get special permission, believe it or not, from the superintendent of public instruction, or you have to get permission from a judge. So, you know, we have seen that issue. It seems to have gone down now that a lot of the kids are actually back physically in school, or the hybrid model is kind of more accepted now. But we do regulate that, and we will continue to monitor that, you know, going forward.
Thank you.
And thank you, Assemblywoman. Next, we'll go to Assemblywoman Considine, please.
Thank you, Chairman Flores, and thank you, Commissioner Chambers. That is a lot of information, and it rolls right into my questions. You stated that you have the same number of staff that you've had since 1999. Meanwhile, our population has expanded. Lots of new employers have come into Nevada. You have stated that you work with employers, which is fantastic, you know, resolving issues instead of, you know, penalizing them for just learning what they're doing or getting information and opening that door for them to reach out to you. But I know that that is time intensive. So my question is, what is the effect of not having additional staff? Does that mean that there's a lack of enforcement? Does that mean that the timeline for enforcement is getting longer? Do you feel like you are responding as quickly as you could, with, you know, if you had more staff on that? And specifically for my district, I'm hearing issues going on right now about wage theft claims. Are those getting to you, especially during COVID? And are you able to respond to those, or what is that level of responding to those?
So again, Shannon Chambers for the record, thank you for the question. So obviously, if we had more staff, we would definitely have more visibility, and we would have more ability to monitor not only public works projects, but to probably monitor specific industries. You know, I'm part of an administration and part of a director, and we are a general fund agency. So the ability to request positions has to go through a whole process. And I commit to you that I'm working on some things in our budget to try and get an additional investigator. But I would say that we really, by moving things online, we have really not slowed down in terms of processing of wage claims. If there's specific individuals or whoever that, you know, you and I need to follow up offline, that they say their claims aren't being processed, I'm happy to look into that. But we are resolving claims. We're up to 83% of claims are being resolved within 90 days. So we really have not slowed down. I think where I would like to have more of a presence is just being able to have an investigator that can go out and actually visit a location or visit the employer. So I would like more, but I don't think we're not doing what our statutory and regulatory responsibilities are.
Just one quick follow-up. So if you are looking for an investigator for them to go out, does that mean that currently you don't have enough investigators to go out to do all of that research?
So again, Shannon Chambers, Labor Commissioner for the record. No, we are still going out. Obviously, the COVID-19 has limited some of that. We do have investigators that go out in the field. We still do that, but obviously more would be better. And I'll just put that in the context of public works and prevailing wage. I mean, over 800 projects a year with 9 investigators, you know, we have to be very strategic about where we visit and who we visit. So if we did have more, that would obviously be something that I think would be very helpful. And it would also be helpful to us to work with other entities like the Contractors Board and the Workers' Comp Division to go out and you know, for all of us to kind of coordinate together to go out and visit industries where we know there may be potential issues.
Thank you very much. And thank you for the work that you do for both the employers and the employees.
Thank you. Appreciate it.
Next, we have Assemblyman Matthews.
Thank you, Mr. Chairman. Thank you, Commissioner Chambers. Commissioner, you noted in your presentation that our employers are dealing with what you call valid financial issues. I would say truer words have never been spoken. Of course, you know, Nevada's minimum wage, and I would ask a question in light of your comment, Nevada's minimum wage is set to increase in stages going forward. This is obviously going to be happening at a time when our employers, business owners are struggling to recover. We know also that one of the effects of a minimum wage increase is that it essentially serves as an increase in the cost of labor to an employer. And I'm wondering whether your office has done or has access to any kind of analysis of what the economic effects would be of these minimum wage increases in this sort of COVID recovery context in which we find ourselves. Thank you.
So Assemblyman Matthews, again, thank you for the question. So we do not specifically do any analysis of that. I mean, I'm aware of that conversation since I've been the labor commissioner, and my guess is now with the discussion of the federal minimum wage potentially going up, there's going to be a whole new analysis on that. I'm happy to try and find whatever I've seen on that issue and provide it to you. But we don't do that analysis, and I will tell you, you know, we kind of just implement what the legislature passes, and again, try and educate the employers about that. But I don't specifically do that data in this office, but again, I'm happy to try and locate whatever I can for you.
Thank you. And one more question, if I may, Mr. Chairman. I know there's been a lot of activity recently regarding prevailing wage requirements. I'm wondering similarly if your office has any evidence or is aware of any evidence that expanding prevailing wage requirements actually lead to an increase in construction quality.
So again, Mr. Matthews, thank you for the question. So we don't specifically do that analysis. Again, since I've been labor commissioner, I have seen the analysis on both sides of that issue, to your point, and then the other side that it is better for workers and better for the economy. I will absolutely try and get my hands on whatever I can and provide that to you, but we don't do that in this office.
Thank you. Thank you, Mr. Chairman.
Thank you, Assemblyman. Next, we have Assemblywoman Duran.
Thank you, Chair. Thank you, Madam Commissioner. My question is concerning the regulation of the private employment agencies. So my question is, are they the major employer, and is there a regulation or amount of money that they can charge a person for finding them a job?
So again, Shannon Chambers for the record. Thank you, Assemblywoman Durant, for the question. So they are considered the employer. So when somebody goes in and signs up at a temporary agency, that temporary agency is considered the employer. There is a maximum that they can charge for finding somebody a job, and that is approved by the labor commissioner. and it depends on kind of the structure and the position. So there's not an exact answer, but there is a cap. I will tell you, since I've been the labor commissioner, I have not seen a single claim where an employee paid to get placed somewhere and was not placed or had a problem or an issue. That could be a contractual dispute, but there is a cap. It depends on the position, and we do enforce that. And the licensing statutes under the private employment agency statutes, the labor commissioner can do a cease and desist, can do administrative penalties, and we do that. Typically, what we see is the private employment agency will place the employee somewhere, and then the employer pays the private employment agency, and then they don't pay the employee. So it is an area that it is active, and I kind of mentioned that earlier. The bigger issue with that is unlicensed private employment agencies. So Northern Nevada, you can drive around like on a Saturday saying, come in, apply. We're hiring, hiring today. And so we will go out and do kind of spot checks on those to find out if they're licensed.
Follow up, Chair? Are they responsible also for the regulations that you had, as well as on page 9? Can they not take the deductions and stuff like that out of their paychecks? Are they required by law to follow that as well?
So again, Shannon Chambers for the record, they are required to follow all labor laws in the state of Nevada. There are these entities now, and this is probably going to be a bigger discussion in this session, but there are a lot of companies now out there offering human resources services. So they're kind of in this world where they're not a private employment agency, but they're not a full scale, like a recruiter or something like that. So I'm planning on working on that issue with some other legislators and some other legislation, but temporary employment agencies, which is what these are known as, are required to follow Nevada labor laws, and we do enforce those. And I will tell you that some of the biggest administrative penalties since I've been labor commissioner have been against private employment agencies for not doing what you're mentioning.
I would appreciate if you have any data that you can send to us, and I would like to be involved in a conversation if I may.
Of course.
Done. Thank you. I appreciate that, and thank you, Chair.
Thank you, Assemblywoman. Next, we have our Madam Vice Chair, please.
Thank you, Chair, and thank you, Commissioner, for the presentation on the work that you all are doing. I had specifically a question about SB 207, and interestingly, from the 2019 legislative session, interestingly enough, I just met with a constituent that works a lot with women in trades. We had a conversation about the council's work, and I'm just wondering what work this council has done to reach its diverse candidates, including women and women of color.
So again, Shannon Chambers for the record, and thank you for the question, Vice Chair Torres. So that's not under my jurisdiction. I think you're probably, hopefully you're talking about the State Apprenticeship Council. I can put you in touch with that group. That is no longer under my office, so I wouldn't have that data, but happy to put you in touch with the people that would.
Yeah, thank you. That would be really appreciated, as I think that's a really important issue. And Chair, I have a second question, if I may.
Please.
Thank you, Chair. And I recognize that the office is understaffed, as a number of my colleagues have kind of called out. I think you all are doing quite a bit of work with a small team. I really appreciate the work that you're doing for our hardworking Nevada families. And I'm just wondering if we've looked at other co-enforcement models that would allow for unions to be a part of that process, or workers' coalitions, or legal group providers, so that we can kind of take off some of that load.
So again, Shannon Chambers, Labor Commissioner for the record, and thank you again for the questions. So your questions are absolutely right on point. And I will tell you that in January of 2020, which seems like an eternity ago, I was starting to have those conversations about co-enforcement with some of the community groups and different organizations like that, and the unions, and then just kind of That didn't go anywhere, and I'll just put it the best way. And then COVID happened, and certainly plan on bringing those conversations back. I will tell you, in terms of on the union side, especially in the construction trades, they work very actively with our office and are typically, besides contractors, are typically the ones bringing complaints to our office, and they often perform the initial investigations of those cases. So that does work very well. But I would be happy to have a follow-up conversation with you as well about specific groups that we could partner with, because I think your point is absolutely right on. And a lot of other states are having to do the same thing, just because of resources and the budget situation.
Thank you. I'd appreciate that information. Anything we can do with that so that we can get a hold of these cases and manage them quicker.
Thank you, Madam Vice Chair. Next, we have Assemblywoman Brown-May, please.
Thank you, Chair. Thank you, Commissioner Chambers, for your very detailed presentation and the robust information that you provided to us. My question is relative to the bulletins and guides and claim filing that you talked about, and how are we reaching multiple populations? Really for Spanish-speaking families that are very predominant throughout the Las Vegas Valley and our entire state, and then people who are blind or visually impaired. How are we making sure that we have multiple languages and accessibility in all of our bulletins and communications? If you could just give us a little bit of information about that.
So again, Shannon Chambers for the record, thank you for the question. So all of our bulletins and our forms are in Spanish, so we do have that. My investigators, I'm kind of the odd person out in my office, is that I don't speak Spanish, and I will say that up front. All of my investigators in Southern Nevada do speak Spanish, and I also have a couple individuals that speak Romanian and various things, so I'm kind of that. So we do outreach as much as we can to those different agencies. In terms of hearing impaired or blind, we're kind of subject to the state rules in terms of our websites and ADA compliance, and that's more of a resource issue on just a state level. But we do try and comply with whatever the state mandate is in terms of ADA compliance and whatever EATS, so it's the Information Technology Group, tells us to do. But I can't tell you something specific that we've done. We tend to fall in the state umbrella on those. But again, all our bulletins, claim forms, we do have Spanish versions of those. And like I said, my staff, we have a sufficient number of investigators who do speak, especially Spanish, and they are mainly in Las Vegas. So, but I'm happy to have a follow-up conversation if you have better ideas about how we could do that. And I would be happy to pass those on at the state level too, because we just kind of follow what the state people tell us to do.
Thank you. Thank you, Chair.
And thank you, Assemblywoman. Our final two questions are from Assemblywoman Martinez, and then we'll move over to Assemblyman Ellison. Assemblywoman Martinez, please.
Thank you, Chair. So the question that I have is, how does the commission determine that the sacrifice breaks are a request of the employees and not of the employer?
So again, Shannon Chambers for the Labor Commissioner. So are you talking about the request to waive breaks?
Yes, that is correct.
Sorry. So thank you, Assemblyman Martinez. So I will tell you, it kind of goes like this, and I'll put it in a real example. So we will get a request from an employer saying, we want to waive the breaks and lunches for our employees, and everybody wants to do it. And then the follow-up question is, well, if everybody wants to do it, then they would be more than willing to sign something saying they know exactly that they're waiving their breaks and lunches and exactly what they're doing. And then we never hear from that employer again, because we always require that if an employer is going to do that they have to document specifically the business need, and they also have to document that every single employee signed and agreed to that. So if that doesn't happen, we do not approve an exemption. Now, I am aware of employers doing this informally, outside of our office. We try and advise them not to do that, that you should always have something in writing and always have the agreement of the employee. But we do grant those. I will say it's probably up to about 6 this year. But again, we always require all the backup documentation in order to approve one.
Thank you.
Thank you. And lastly, Assemblyman Ellison, please.
Thank you, Mr. Chairman. I just got a couple. One of the things you did say in your testimony just now is that most of the unions are bringing in the complaints, and then on top of that, they're doing most of the investigation. Isn't that like putting the fox in the hen house? We're still a right work state.
So again, Shannon Chambers for the record. Assemblyman Ellison, thank you for your question. So just to clarify, I did say that the unions can bring complaints, and many of the complaints they bring, they have already done an investigation. That does not mean that we don't do an investigation to actually see if what they're bringing is valid or not valid. So that is definitely a legal requirement in our office. But under Nevada law, the unions and the trade organizations, and as I said before, kind of really anybody has the right to file a complaint with the labor commissioner. And then we look at that and do our own investigation after that. So I certainly don't want you to feel that we just take the union investigation and do whatever the union says. Believe me, I've been sued enough in this job because I didn't do what the union said. So we definitely do go the next step and still have to validate whatever the claim is and whatever the investigative findings are.
Okay, I appreciate that. And I have a follow-up if I may, sir.
Please.
One of the problems that we're having in rural Nevada is, trying to get workforce. And in some of these small, real rural communities, and they've got small projects that is a prevailing wage, and trying to comply to the apprenticeship program is ridiculous. So we had a large meeting, and we had Brenda from LCB that logged in on it, and Senator Gogachi and I both were there. But trying to call and get somebody's permission if they want to send somebody for 2 days to a project, or 3 days, or whatever, even a week or so, way out in rural Nevada, to go out there and work with somebody on a cat, as a labor for a shovel, handle a shovel, or something like this. It's ludicrous to try to get that, and by the time you get their authorization that they don't have anybody who wants to go out there for a short period of time. It's kind of crazy. And I think this is one of the things we have to deal with, because you got places like Battle Mountain and Eureka and Ely and Wells and Wendover and Jackpot. It's just crazy to try to get somebody up in there for short periods of time, and some of these laborers onto the apprenticeship program. Can you answer that?
So again, Shannon Chambers for the record. Assemblyman Ellison, thank you for your question. So I am aware of those issues. What I would say as the labor commissioner is I've been given a law that I have to enforce, and I'm trying to enforce it in the most reasonable and practical and I think efficient way that I can. I'm certainly aware of those issues, and I will tell you, we try to work through those issues on a case-by-case basis. And I have done some work with some of the entities out in Elko to try and speed things along, and some of the entities in Battle Mountain. But I cannot, and I will represent to this committee, I don't want to carve out exemptions that don't exist in the law without having a healthy conversation with this body, or without having it go through the regulatory process. But I think your comments are fair. I don't think they're new. I think, as this bill was going along, those were some of the concerns. And I'm happy to work with you, and happy to work with anybody to kind of come up with some better rules or guidance. But I certainly don't want to be the labor commissioner that makes up rules and doesn't enforce the law without having that conversation with you and with this body.
Well, I really appreciate that. And we've got a problem, and we got to fix it. And I'm hoping during this body that this session, we can at least fix part of that. Because I can tell you, it's by the time you got to add it into your bid process prior. So if you're awarded, then that's where the problem comes in. And so I'm hoping that the salary doesn't change. It's just trying to get somebody here, trying to get somebody to give you a waiver is the problem, and you're holding up projects. So I can see it on large projects, but I can't see it on smaller ones at $100,000 and above. So I'm hoping we can address this session, and I'm hoping that we can get LCB involved with this because they were at the beginning. So I thank you very much, and I really enjoy your comments about it because you can see the problems are going way out here in rural Nevada. So thank you.
No, and again, thank you. I understand and certainly aware.
Yeah, thank you.
And members, thank you for your questions. And like I said, we will have an opportunity to continue to revisit some of these topics. We'll certainly be hearing a lot of bills where we'll be asking the office of our labor commissioner, please come in and give us some guidance as to what they're doing and what they're seeing on their end. With that, I'm going to go ahead and close out the presentation. Again, Commissioner, thank you for being here, and I look forward to working with you this session. A broadcast, if we could please go to anybody wishing to speak in public comment.
Thank you, Chair. Caller with the last 3 digits of 905. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Hello, and thank you for letting me speak. My name is Evelyn Pacheco. I am founder of Nevada Women in Trades, and I am neutral for SB 207. And thank Assemblywoman Torres for speaking on my behalf, but I would like to amend and include a percentage of women for the SB 207 bill.
And thank you, Mr. Pacheco. I appreciate your spirit. I've had the opportunity on numerous occasions to share a conversation with you about getting more women in our trades and how important that is, and how empowering it is for you to carry that badge proudly. I believe our Vice Chair, Torres, also had a comment for you.
Thank you, Chair. And I just want to, make sure the committee recognizes all the good work that Evelyn Pacheco does as chair of the Nevada Women in Trades, as she is also the first African-American female plumber in the state of Nevada. So if we could have her up here with us in Northern Nevada, we would welcome her into our chamber, especially in honor of African-American Heritage Month. She's also a constituent of mine, so I'm excited to hear her on the other line. Thank you, Ms. Pacheco.
Broadcast.
Thank you, Assemblywoman.
Thank you, Ms. Pacheco. And if we could please go to the next caller.
Chair, the public line is open and working, but there are no more callers at this time.
Thank you, broadcast and staff, as always, for your wonderful work. Members, we'll be back here tomorrow morning. We have 3 presentations scheduled. And then Friday, as I previously stated, we have 2 presentations followed by 2 bill hearings. I wanted to yesterday, and I completely forgot, so I'll do it today. As you know, members, yesterday was Nevada Tribes Legislative Day, where we celebrate and recognize the American Indian community contributions to the prosperity and diversity of Nevada and the U.S. as a whole. I just wanted to adjourn today in gratitude to the contributions of our tribes, namely and specifically in appreciation to all those tribal members who work in this building and every day make our jobs a lot easier, and just for their sacrifice and tireless work here. I'd like to adjourn in their honor. And with that, this meeting's adjourned.